Hey everybody, welcome back to the AV7 channel where we talk about all things law, true crime, and a little bit of debauchery. Welcome back to your weekly YSL Fix. We've got a lot to cover this week, so let's dive right on in. From major courtroom drama to the judge's critical rulings, it's been a wild ride. Let's break down everything you need to know. And before we go anywhere, please check out the sponsor of today's video, Aura. If you want to protect your data, your privacy, your credit, and stop robocalls, please check them out. You have a free 14-day trial using my code below. Let's get into it. On Monday, we started the week with a heated discussion involving Lil Woody's attorney, John Melnick. He revealed his involvement in the controversial ex parte meeting, where the prosecution team apparently had reason to believe that even as a witness, Lil Woody was represented, though they failed to contact his attorney.
A motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying?
I do.
You never once asked the district attorney's office what protections the immunity afforded to Mr.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms. Hilton in the presence of an investigator that you had never heard of OCGA 24-5?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him immunity.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally, in writing to the email that is labeled Defendant Williams Exhibit Number 5, you wrote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client."
Yes.
So what specifically did you intend to, you didn't include in here anything particular that you were worried about with the immunity deal, but you were very specific about Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Exactly.
Now, are you asserting that he is in danger from any member of the state from testifying?
No.
And what specifically did you want, more specifically, because you do understand it's not an immunity deal. We can't use anything he says in any way against him.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he had received that, what much more specific information did you want to see in the?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity for anything he was asked about criminally, was from the state or the defense?
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him to prosecute from those acts? You didn't understand.
It protects him from his testimony at trial being used against him, Ms. Love.
And anything derived from that testimony.
And anything derived from that testimony.
Let's speak one at a time. Anything derived from that
testimony. Are you aware of that?
Yes, ma'am.
So given that Mr. Copeland could not be prosecuted for anything he testified about, and the state could not use his testimony to go seek additional information or reasons to prosecute him, what is it that you would have been seeking to get?
So we are getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all on stage.
Yes.
And could you tell us just why it is that you would have felt that that was
I think that's
something that should have been avoided?
I'm not going to get into that.
Not.
I'm not going to get into that, Ms. Love. I'm not going to get into that.
Yeah, I think that's all that I can think.
Kayla Bumpus, a stand-in attorney who has been criticized for focusing more on her YouTube career, took the stand. The judge wasn't buying her story and found significant holes in her testimony. It was a rough day for the defense.
I saw some shots. Like, it was almost rude when she basically intimated that you didn't even know what ex parte meant. Like,
yeah, I mean, we were both playing at that point, because what I was saying was, she asked me, when did I know about an ex parte or whatever. I mean, like, I don't know what she asked me, but
yeah, that was
my whole thing was, I was supposed to be there to talk to my client, and they turned it into a meeting. Mm-hmm. And that's what I was trying to tell her. And there was never a time to process it until it was done.
Yeah, I hear you. Like, when I just listening to this as an attorney, like, this judge, it seemed like she was, and we all have seen judges go out of their way to try to embarrass attorneys. It has happened to me. I think it's happened to every attorney where a judge just doesn't like you for some reason and wants to shine.
Well, I didn't feel embarrassed in any shape, form, or fashion.
No, I'm not saying that you were embarrassed. I'm just saying that the judge was going out of her way to try to embarrass you, because some of the stuff that she was saying was.
Kayla, can I ask you this? Like, do you think it's because she's trying to get up to speed to everything?
Yeah, I didn't feel no kind of negative energy from her. And it's just
wait. You didn't feel no kind of negative energy from the judge when she basically implied that you didn't know what ex parte meant?
I mean, my answer solicited her response. I did not answer her question. I understand that. I answered it in the way that I chose to answer it. And so,
yeah, but my question, you're saying that you didn't feel any type of negative response from the judge, but she's implying that you, as an attorney, you've been practicing 7-8 years. She's saying that you don't know what ex parte means.
No, I think that was taken out of context. I think she didn't like my response, so that was her response.
But that was a negative response, right?
Well, I think that she did not like the way I responded, so I could not be mad at her.
Okay, so you're saying that
I was trying to be
negative response, but you can't be mad at her negative response.
Yeah, I mean, I don't think it was negative energy. I just think she's like, and that's what I say. Everybody has all these opinions watching from the TV, but to be in the courtroom, it feels completely different. Like, just the perception on the internet is way different than the energy in the courtroom.
I hear you. Maybe it's me. Maybe because I've been practicing a long time. But if a judge was saying, Lee, you don't know what ex parte means, and we learned that in the first year of law school, I would be highly insulted. I'd be like, Judge, you're trying to insult me.
Well, I feel like it's because of what I said.
But that's fine. You can say a lot of things, but the judge doesn't have to insult you. That's what I'm saying. That's what I'm saying.
I understand. But I just feel like for the most part, I think I've been saying this from the beginning. It's nothing that can really happen in this case. I don't think that's going to lead to a mistrial because she wants to try the case.
Oh, yeah, because a lot of people are saying that. A lot of people she's being very precise with her language about, if this case reaches a conclusion, if we bring the jury back, if Woody testifies, she's kind of leaving a large door open for a mistrial. But you don't think it's going to be a mistrial at some point? You think she's going to get to a jury verdict?
I don't know, but I think she wants to try the case. I don't think it's going to be easy. But one thing I can say that I'd appreciate out of everything from today that she said was, after hearing evidence and testimony from both sides, that she was going to reconsider the Brady situation, the Brady violations, and, take that under reconsideration. And that meant a lot to me. It made me feel like my testimony wasn't a waste.
Yes, 100%. I think someone said that she's considering, I guess, throwing all, and you have to forgive me because I haven't been up to speed on this, but I think she's been considering throwing all of Woody's testimony out and then starting over. Have you talked to Woody about that? About him possibly testifying in this case again?
Of course.
Yeah. I don't know what Woody's doing. Woody's killing the internet, man. Every time I see him, he's on a video and it's got over 1 million views.
Yeah, he was in court today.
Oh, he was in court. Okay.
I mean, he didn't come in the courtroom, but he was at the courthouse today.
Was he showing up in case maybe they called him or?
Well, in case Melnick needed him.
Oh, okay. Is there any clarity on when he might take the stand again?
No, not that I'm aware of.
Because I remember, I guess last week or the week before, it seemed like the judge was aiming for today, for August 5th, for Woody to come on. But then the case kind of got, it kind of drug along. And now who knows when he's gonna come back. Do you know if you or Melnick still represent Woody, or does Woody need representation, or kind of what's his stance now?
I don't think he needs representation, but he knows that he can call me.
Mm-hmm. If he needs anything.
Yeah.
Man, I hope you charge Melnick. I hope you get Melnick on the phone and be like, brother, we do favors for each other, but you got to break me off something on this one. Because you have been through so much. But you've been rising, and it sounds like from what you're saying and what AV is saying that when you first testified today, kind of the tide changed. But then I guess after another witness testified, people started coming back to you and reaffirming that you in fact weren't lying.
Yeah, no, I mean, I got on live right after I testified, and like 2,000 people were on in 2 minutes, and it was it was nothing but positive vibes. And then when I got on, there was a few people. I'm not gonna say nothing, but it's still about a 80-20, which has been consistent for me. I got the gray dress, 80-20, the green outfit. What you say about my gray dress?
Listen, no, the gray shit. I want to be respectful because
I try to tell you all the time, stop talking about people.
I want to be respectful because Caleb Bubba's got a man, but listen, you're looking right. You are absolutely looking right. So shout out to Caleb. I was like, damn, boy.
All right, good night, you guys. Thank you, Lee. Thank you for always being nice and supporting me.
I'm saying you looking right. That's not being
thank you.
Okay, I got you. I misunderstood.
I'm exhausted and I'm about to go to sleep. But thank you for always supporting me. I really appreciate you, and I appreciate you too, AV. Thank you so much.
Of course, anytime.
Yes, and you can always come on. And then this is my first time watching, so maybe I'm a little bit too critical. If I say anything that ruffles your feathers, I apologize for that. I am calling it fair though, because this judge is out here headhunting, and not just about you, with love, but she's sending some shots, and this isn't her first day. So I'm just analyzing it, right? But you are always welcome any day to hit the link and come up. And if I say something that's wrong, you are welcome to correct me or to clarify anything, right?
No, I appreciate you so much. And then after you look at long, then we'll talk again.
There you go. Do you anticipate having to testify again?
No.
She's like, I'm telling her. All right, everybody write Kayla in the name chat. And Kayla, if you testify again, where that green thing? The gray one. All right, put guys. The green or the gray?
Right,
I like the gray. Shout out to Kayla. Thank you so much for coming on, Kayla.
Okay, thank you.
All right, I prefer to. I don't know. This is a tough call, but that gray was great. All right,
I'll see why I want to spend more time on my channel. This is this is the worst.
Listen, this channel started off when I had 2 subscribers. This channel started off as a men-centric channel, and I will not change for wokeness. All right, no, we are sticking true to where we come from. All right, the woke mom. No, Lee, she has a man. Well, shout out to her man. All right, we just admiring that man's taste. All right, so shout out to Caleb. And it's all jokes, guys. We just having fun. Caleb know my heart. All of y'all know my heart. I'm a lead, guys. Come on, y'all know what it is. All right, so let's get back into it. And shout out again to Caleb for coming up and calling me out. Like, hey, Lee, heard you to talking shit. So we not doing that. We just calling it like we seeing it. All right, so let's go.
Is it safe to say you don't know why they were told to turn off the body worn camera?
That is correct.
Okay. Did you ever hear anyone from the state ask the deputies to have those body worn cameras turned off?
No.
You testified earlier that Mr. Copeland said something akin to, I can claim all of this. Did I hear you right?
Yes.
Okay. And who was he talking to? And
Simone.
Okay. And did you know, or did he ever make clear what all of this was that he was talking about?
I believe he was referring to everything that,
Wait, that's not the question. It wasn't what do you think he meant? It was, did he ever make clear?
he said everything in this case.
He said the words, everything in this case?
I don't know if those were his words verbatim, but that's what he said.
Was the court reporter there when that happened?
I don't know. This was an off the record conversation.
Okay, so it was off the, so when what about his words? What words did he say that makes you now say that's what he said if you don't remember exactly how he put it?
I said I don't remember his words verbatim,
Right.
but I was there and he said, I can claim all of this. I can take all of this. That's what we were talking about. We were talking about this case.
Okay. Is what you just testified to the extent of the words that Mr. Copeland spoke regarding claiming something?
Can you repeat the question?
Yes, ma'am. It's what you just testified about, the extent of the words Mr. Copeland spoke about claiming something.
I really don't understand the question.
I don't want to say that is a complete lead to the extent because he said it over and over. He said it various ways. He changed the way he said it.
Do you recall what specifically was being discussed at each of the points that he said that?
Overruled.
Specifically, not generally, not broadly.
That's such a huge
what was being
question, though.
discussed at each of the points where he said, I can claim all of this.
The whole conversation was about Donovan Thomas's unaliving.
Are you familiar with any of the shootings that occurred after Donovan Thomas was killed?
No.
Okay.
Tuesday brought more drama as Lil Woody returned to court. He learned that his rights were violated with improper instructions given to him by the prosecution team, especially concerning his potential contempt charges. The judge made it clear that Woody would not be held in contempt longer than the duration of this trial, just this one, contrary to what he had been told previously by the predecessor judge, Judge Glanville. The big decision looms on the horizon as Woody is set to return on Monday to decide whether or not he'll testify.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning
Already
from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth. And in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said it at the beginning.
Didn't understand anything. All right. So
No, I'm saying, like, I heard you, but I don't know what you're talking about.
okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity.
Yeah.
What you mean?
Okay.
Here we go.
Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah. The same one as last time. Yeah.
Yes.
That one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier. And I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions?
Mm-mm.
Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state.
huh?
I have told the state I have lied and lied and lied and lied.
I know. And
So how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're going to be able to charge me if I lie. Like, when
Perjury.
it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that you know he didn't do, and well, maybe not. Never mind. Don't do
Can I
that.
give you an example for what they told me?
Yes.
Yeah,
Go.
yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
Oh,
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay. Right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime. Here's what I committed it with. I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't
formally
have
call it.
they facts together? Like they saying something they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated
Here's the
to
question.
come.
Here it is.
I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
Here we
Depending
go.
on how I wake up.
Okay. All right, well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning.
Wow.
You're free to go for now.
Wow.
Now let's dive into Lil Woody's decision. As we head into the week, all eyes are on Woody as he prepares to return to the stand on Monday. The burning question, will he choose to cooperate and testify, or will he invoke his Fifth Amendment rights? This decision is a critical one for several reasons. For Lil Woody, choosing to testify could potentially expose him to further legal jeopardy, depending on the questions asked and the answers given. His cooperation could also solidify his role as a star witness for the prosecution, but it's not without risk. If he testifies, he might reveal information that could be damaging not only to the defendants, but possibly himself if the defense manages to poke holes in his testimony. For the prosecution, Lil Woody's testimony could make or break their case. This entire case rests upon Lil Woody's testimony. They've already faced criticism for their handling of witnesses and the ex parte meeting debacle. If Lil Woody decides to cooperate, it could strengthen their position, providing key evidence that ties the defendants to the charges. However, if he invokes the Fifth, it would deal a significant blow to their strategy, potentially leaving them without a crucial piece of the puzzle in this expansive RICO case. On the flip side, the defense team is likely hoping that Woody will refuse to testify. If he invokes the Fifth, it could cast doubt on his credibility and weaken the prosecution's case. The defense could argue that the prosecution is relying on a witness who isn't willing to stand by his statements, saying things like, I did these crimes, raising questions about the overall strength of the case against their clients. Whatever Woody decides to do, it's clear that this moment will be a turning point in the trial. His decision could tip the scales for the other side, and it's something everyone, judge, jury, and the public will be watching closely. Wednesday. Midweek, all eyes were on the lead prosecutor, dubbed Lawyer Love by some. She had a lot of explaining to do as it became increasingly clear that her team was unprepared. In an embarrassing moment, Lawyer Love struggled under pressure as her colleague Hilton was away with her boss, Willis, in Boston for a prosecutor's event, where one of them was even awarded. The prosecution's lack of readiness is becoming a recurring theme.
So this is what Shar's going to say. Shar's going to be like, hey, guys, Judge, she said yesterday it was on accident that she didn't give us the information. Today she says it's on purpose. Which one is it? All right, let's listen up, guys.
Hold.
So the answer is no on that one.
Correct.
Two things, Your Honor. First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
And I reached out to the investigator who got that last night. That person, I can provide information to the court and Mr. Chart as to what is happening to the lady that on their end.
Is there some reason that can't just be shared right here and now?
They're trying to thwart a murder.
They're trying to do what?
Thwart a murder that is underway or being.
Okay, then seems they should pass off the responsibility for getting the affidavit to someone else.
Oh my God, that tone.
My legal assistant is looking for the affidavit.
Did you in any way respond to Mr. Sharp?
No, I didn't see that.
And I put the Zelle information in the banner there. So we'll have it there for the future as well.
That's part of what I provided to the court this morning. What I'm waiting on is my legal assistant, because the person we were able to communicate with at the door.
Explanation.
The investigator said that the affidavit
Uh-huh.
was provided to us.
Uh-huh.
So
The affidavit was provided to us as in, I don't know what. Well, I mean, I would assume so.
So we have it, we should have it to give to Mr. Char and to the court. I'm awaiting that to provide it to the court, Mr. Char.
Okay, and so you didn't see the emailed request from Mr. Chart last night that said, could we?
And the email was
Mr.
actually
Records.
sent to.
And I want to be clear, and I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either. Obviously, I meant search warrant and affidavit, but I did put search warrant. But we haven't received either.
And what time did you send that? It was
1:53 p.m.
so yesterday afternoon. Okay. Okay.
So the judge is kind of like, man,
Okay.
there's
So
information that hasn't been turned over.
I understand that I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent. And this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him.
Okay, so what do you guys think? What do you guys say? Like, how do you get out of this situation? If a judge is saying, hey, yesterday you said it was on accident. Today you said it's on purpose. You are an attorney. You are an officer of the court. You have a duty of candor. You cannot lie to the court. You cannot lie to me. Yesterday on the record, you said it was an accident. Today, you're saying it's on purpose. Now put yourself in Love's shoes. How do you get out of it?
Right.
How do you get out of it? If your wife is saying, hey, yesterday you said you didn't do nothing with that girl. Today you're saying that you did, but you're sorry. Which one is it? Did you do something with her and you're sorry, or you didn't do nothing with her? Which one is it? What do you say as a man? Let's see what Love says.
There was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested, and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Which is it?
Thank you. They are both. I asked the court yesterday.
Oh, she said both. Oh, she said both.
That's terrible. It's so disappointing. It can't be.
Lee, you said yesterday you did something with her, but you're sorry. Today you're saying you didn't do nothing with her. Which is it, Lee? Shit, baby, goddamn. It's both. I mean, what had happened was, it's both. Let's listen to her try to get out of it. Oh my God.
With the defense, because Mr. Boyer had not yet been arrested, and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked
She said both.
So allow me your time to speak with team members.
Right.
Talk on the mic.
Information internally that I know is that when the phone records were initially secured.
In the fall of 2023.
Y'all notice how now she's not talking on the mic?
Yes, when
Yes. Okay.
they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial,
Who talks like this?
Do you know when?
Y'all see the pauses? Where? Judge. Our team. Judge. Who talks like that?
It's like a CD skipping. Like
Let's guys, just pay attention to the pauses. Go back and just pay attention to how she's talking.
the thought process was, we're going to get this person arrested and indicted.
Okay.
Uh-huh.
As time went on,
What?
skip.
our team had the records, and as we advanced in trial,
Uh-huh.
Look at the judge's pen.
Who talks like this? This is who, man, when you're prosecutor, what if you if your wife catch you with that girl and you're like, baby, I know we got these kids, baby. I know we got this home equity, the F-150, I know child support, alimony, I know, but let me tell you what happened now. I went into my car, all right? I was driving over there. Okay?
Mm-hmm. What else?
And it's like, guys, it's the middle of trial. The biggest trial in the state history, and she's talking like this. Who talks like this?
as time went on, our team had the records, and as we advanced in trial,
Uh-huh. Guys, put a fork in this lady. Put a fork in this lady. And she's done. She is done. Let's go, man. Jesus Christ.
Do you know when the decision, if there was one, was made? Okay, we're not going to get a warrant for him after all.
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there is still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. That person wants a warrant. So there's not, the decision to obtain the warrant has not been abandoned. The
Okay.
efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And it wasn't time progressed.
Thursday, we saw more of the same. Lawyer Love's unpreparedness was once again on full display. The court focused on preparing witnesses and getting ready for the jury to return on Monday, all while trying to maintain some semblance of efficiency. But after countless examples, it's painfully obvious that the prosecution team is certainly not prepared for this expansive RICO case. The question on everyone's mind, will they be ready when it counts?
I know. So we will search our collective memory.
Okay.
And if you, I am really interested in speaking with Mr. Sharp about what he is talking about, so that I can understand where.
All right,
So
I'm not
I
sure he knows.
Different. So, somebody has said the word Brady or something, and I don't. Well, I will talk. We will
Okay.
search our collective.
Something inconsistent.
Did anybody take notes? I mean, we had 4 people there. Nobody took notes. Nobody recorded.
I don't know that we know that. I don't know.
No, I'm asking. We're entitled to it if that's what happened.
Well,
So
Brian's standing up.
Mr.
Brian's
Harvey, talk
standing
to
up.
me. Don't talk across to opposing
I am
counsel.
not. I am just somewhat astounded that we had 4 people meet at a coffee shop and nobody took note number 1. Nobody,
Mr. Harvey, no one
Nobody
has made that
recorded it?
assertion.
nobody recorded it. I'm asking if there was a report, if there were
First of all, you got Braid Man. You got the OG standing up. Do y'all see Brian's stance right now? Let me back up off the mic because y'all don't like it. Do y'all see Brian's demeanor right now? He was just standing before Bruce said anything. These are the OGs of the defense side. Okay? This is a dumpster fire lit up. All right? It's already been burning. But somebody just walked around with gasoline and tossed it in the dumpster.
notes taken. If there was a recording, we
Okay.
would have something to review to determine whether or not there was something
Okay.
that should be provided to us.
Okay.
Okay?
I don't know whether that happened or not.
I would, if I had I did not record our meeting, our conversation, because I would have turned that over. I did not record our conversation.
Okay.
It was literally a conversation,
Right.
and that's it.
Okay.
I got Mr. Lee.
Yeah, I love this drink.
Where you
chance
put my
with you. I
bag
like
at?
when you like this, Daddy.
Yeah, where you put my bag
Daddy,
at,
I like
Mr.
when
Lee?
you
Oh, it's right here, it's
scrambling
right
and
here.
scraping.
No.
Friday wrapped up the week with 4 major rulings from the judge. She denied a motion for a mistrial. She denied a motion for a fair trial. But the disqualification of the prosecutors was also denied, and also issued an order on the alleged ex parte violation. These rulings are critical as we head into another intense week in this high-stakes trial.
The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of the prosecutor.
What? Hold on, I gotta read this. The court therefore orders, as a remedial measure for stealing all the gold, that the entire prosecutorial team working on this trial submit to training on Brady and other professional obligations as a prosecutor. Oh, they're gonna watch it. They're gonna watch some training. They're gonna receive some training. Why you shouldn't steal the gold.
Here's why you shouldn't steal the gold. Here are the ramifications of stealing the gold. It's just like they know better. You said they were experienced.
You said they were experienced.
That's it for this week's YSL Fix. Next week is shaping up to be just as intense, with Lil Woody's big decision and the jury returning to the courtroom after a month off. Make sure to subscribe, hit the notification bell so you don't miss any updates. As always, drop your thoughts in the comments below. What do you think will happen next? Let us know. Stay safe out there. See you in the next one. Bye.